And this is People of the State of Michigan versus Janovan Price, docket number 20-852FH. Mr. Price, you are here today because a bench warrant was issued. It was issued based on allegations that you are in violation of probation. It's alleged here in count 1 that on or about June 12th of this year, you engaged in assaultive, threatening, and/or intimidating behavior against Mariana Price. In count 2, on or about June 12th of this year, you possessed a firearm, a handgun. In count 3, on or about June 14th of this year, you failed to report police contact that occurred on June 12th. Count 4, on or about June 12th of this year, you were in possession of marijuana. And in count 5, that you failed to make regular monthly payments towards your assessments since your sentencing on February 1st of this year. Do you understand the allegations against you?
Yes, Your Honor.
If they're proven true, it could subject you to a maximum penalty of up to 2 years in prison based on your original conviction. You have the right to be represented by an attorney. You are represented by Mr. Austin. You also have the right to a contested hearing where you could appear by yourself or through an attorney. You could hear the evidence presented against you. You could cross-examine witnesses, and you could present your own evidence. And Mr. Austin, can you tell me how we're proceeding on this?
Yes, Your Honor. Count 1 is the subject matter of a pending case at the district court. I would ask the court hold that in abeyance. And from speaking with Agent Teedsort, I believe he would be moving to dismiss the second count involving the firearm. And it's my understanding with speaking with Mr. Price is he would be admitting to the balance of the violations.
Okay. Is that right, Mr. Teedsort, your understanding too?
Correct, and the reason we don't want to proceed with count 2 is a lack of evidence to support that. Thank you.
Okay, thank you. Then counts 1 and 2 are dismissed. And Mr. Price, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Mr. Price, you have the right to a contested hearing, as I've already mentioned. If you plead guilty, you won't have a contested hearing, and you'll give up the rights that go along with it. That includes the right to be represented by an attorney at the hearing, the right to have the allegations proven, the right to have the witnesses against you appear at the hearing and to be able to cross-examine them, the right to have this court order any witnesses that you might have to appear at the hearing, and also the right to testify yourself at the hearing if you wanted to. Do you understand those rights?
Yes, Your Honor.
Has anyone made any promises to get you to plead guilty?
No, Your Honor.
Anyone used any threats or other kinds of pressure to get you to do this?
No, Your Honor.
Are you pleading guilty because you believe you did violate probation?
Yes, Your Honor.
Okay, so on or about June 14th, did you have did you fail to report police contact to your agent?
Yes, Your Honor.
Okay, so that contact occurred on June 12th, and then you never told your agent within 24 hours, correct?
Yes, Your Honor.
Okay, and on June 12th of this year, did you possess marijuana?
Yes, Your Honor.
Did you know that you were in possession of it?
Your Honor, it was in my backpack. I haven't used that backpack since before I got on probation, but it was in there when I got arrested. So I didn't know I had it in a backpack, but it was in there, so I was in possession of it. Yes, I was in possession.
Had you originally put it in the backpack?
Yeah, I had forgot I put it in there a long time ago, but I haven't.
Understood.
I haven't used that backpack before. Sorry.
Okay. And is it true that you haven't made any payments towards your assessments since you were sentenced on February 1st?
Yes, Your Honor, but if I can speak, I was gonna try to pay that in full, but
okay. The court finds the plea is understandingly, voluntarily, and knowingly made. It is supported by the testimony. The plea of guilty is accepted. Mr. Price is found guilty of probation violation. Is there a recommendation, Agent Teedsort?
Yes, Your Honor. With this information, we did present that to the court, And the counts that were dismissed are actually probably the most concerning ones. I don't know if, on behalf of the prosecutor, if they know where the status might be, if they're regarding count one. I mean, obviously, we're not dealing with that today, but if there was
No,
any.
I'll just take your recommendation on counts 3, 4, and 5.
Yes, and based on those, and then also on Mr. Price's conduct before the June 12th incident, he'd been on probation now a little over 5 months. He had been complying, and even after the bench warrant was issued, he maintained the employment, still reported to me, still continued with his drug testing, and ultimately turned himself in. So at this time, I would ask for the court to continue his probation. And I don't know at this time if there would be a need for a no contact with the victim. I think there's already an order as part of his bond, and she's reached out to myself and indicated there was a disagreement, but I'm not sure at what level that reached. Thank you, Your Honor.
Okay, thank you. And Mr. Austin?
Thank you, Your Honor. Overall, it sounds like Mr. Price is doing well on probation and making some progress. He is working and gainfully employed, and I believe that he will be able to start making payments towards his fines and costs and assessments that he is owed. So I would ask the court to adopt the recommendation and to continue Mr. Price on probation and not to impose any further incarceration. Thank you.
Can someone tell me how many days Mr. Price has been in the jail on this bench warrant?
I believe he just turned himself in yesterday, Your Honor, so he'd have 2 days.
Okay, thank you.
Thank you. That's correct as far as I know. Thank you, Your Honor.
Right. And Mr. Price, anything you wanted to say?
I just wanted to say I will do better on probation and make sure I don't mess up again.
Okay. What's the situation with you and Mariana?
I currently been living with my grandma on 401 East Edgewood.
Okay.
107.
Okay.
That's my wife, but I haven't been in contact with her or anything.
Okay, very good. Then I will continue you on probation. I think we should add a provision of no contact with Mariana Price and 2 days in jail with credit for 2 days served. The bench warrant is dismissed. And Mr. Price, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. And if you're making a request for one, you have to make it within 42 days of today's date. It tells more about that on the appellate rights form, and we will mail that to you. Do you have any questions before we go, Mr. Price?
No, Your Honor.
Okay, you're all set then. If there's no other hold on you, and I don't know the situation, but if there's no other hold on you, you'll be released on this.
Okay, thank you, Your Honor.
You're welcome. You can tell them at the jail you're all done.
All right.
Thank you, Judge.
Thank you.
Good afternoon.
Hi. Okay, Mr. Smith, is that your client with you?
Yes, Your Honor, this is Joshua Thomas to my left.
Okay, very good. This is People of the State of Michigan versus Joshua Thomas, docket number 21-295FH. This is the time set for hearing on the defendant's motion for a modification of bond, basically to remove the GPS tether. And I'll take your appearances first, please, for the people.
Good afternoon, Your Honor. Jamie Nelson appearing on behalf of the people.
Good afternoon, Your Honor. Tyler A. Smith, Esquire, PA 2780, appearing on behalf of the defendant, Joshua Thomas.
Okay, your motion, Mr. Smith, go ahead.
Okay, I'll keep this brief, Your Honor. Just by way of background, this case involves charges of assault and felony firearm arising from an incident where an altercation took place inside the home of my client, where he was attacked by his father, who is nominally the victim in this case. At the time of the arraignment and the setting of bond, it reasonably appeared to the district court judge that I suppose it must have reasonably appeared to that judge that there was a necessity for a tether in the nature of the charges and other facts that were then known. We've since developed the record. There was a preliminary examination held. We now know that this was an attack on my client inside his home by a man with a documented history of violent offenses. There's only two real reasons that the bond condition of a GPS tether, or really any bond condition, would be set. And those are protecting the integrity of judicial proceedings. And the other is for the protection of named persons. My client has dutifully appeared at every hearing. He's conscientiously observed his conditions. He's doing everything he can to make sure that he complies with his bond conditions. The integrity of these proceedings is being preserved. The other rationale for setting a bond condition, as I mentioned, is for the protection of a named person. The person who, ostensibly would be protected by this bond condition, Genus Thomas, named as the victim in these proceedings. Again, he's got a documented history of violent incidents. And not only that, but in the interval between the original time where the bond condition was set requiring GPS tether, and now the circuit court granted an ex parte personal protection order for my client against Genus Thomas, who is the named victim in this incident. That means that the circuit court found that there was a risk of irreparable injury to my client, such that it was worth granting the petition ex parte. So as it stands, there's little or no rationale to support continuing this bond condition. And in fact, allowing it to continue is, well, I should say as things stand, my client is experiencing some difficulties because of the GPS tether. As part of his work, he works outside in all weather conditions. The GPS tether is a source of some shame. Nobody wants one of these things. So in order to cover it, he wears long pants, which leads to a significant amount of discomfort working in hot, humid conditions as he does roofing, resurfaces decks, things of that sort. Not only that, but it causes other inconveniences, which I'm sure the court is aware of. Just by way of context, my client has no intention of ever approaching or being in anywhere supposed to be victim in this case. It's what he wants to do is avoid this person. In fact, in choosing his housing where he lives, he chose to move to a different part of town to ensure that he does not come within any proximity to the victim in this matter. So I'm sure the court has reviewed the motion.
I have.
Okay. The defendant just respectfully requests the court modify the release conditions in bond such that no longer is required to wear the ankle monitor.
All right, thank you. Ms. Nelson, people's position? You're muted.
Can the court hear me?
Yes. Now I
Thank
can.
you. The people's concern at this point, Your Honor, are that a number of the bases laid out in defense counsel's motion, as well as on the record today, are essentially asking the court to make a finding on some of the factual basis of this underlying case. Certainly, we have a question of fact that's been presented following the preliminary examination to two different sides of the story. And again, the allegations are that the victim, I think it's Genus, I apologize if I'm mispronouncing that, but Genus Thomas was shot by the defendant. And again, I think that some of these factual bases that are laid out in the motion are that which would require the court to make a finding of the facts of this case, which certainly would be more appropriate to be done through a trial. But beside that fact, Your Honor, we don't have any additional facts on this record that would support that there is not a danger posed to the defendant that we didn't already have before the court when the original bond was set for the GPS tether. We don't have any record in our file of any violations for him failing to appear in court. We don't have any notice currently that he has attempted to make contact with the victim or attempted to violate the no contact order. However, I do think that there is still enough significant concern for the safety of that victim while this case is pending that would give the court good cause to continue the GPS tether at this time. Certainly, I do not wish to ever impair someone's ability to be employed or to work. And so certainly if there are some sort of hours or limitations like that the court can modify to help assist with the defendant's employment, I would have absolutely no issue with that. But I believe that asking this court to make a ruling based upon whether or not the defendant was acting in self-defense or anything similarly would again be making a finding of fact in an inappropriate time in this court process and trial process. But again, I don't have any other additional information that he's attempted to violate his no contact order or that he presents any new or additional risk to the safety of the victim that was not already present at the onset of this case. And so we would ask the court to continue the tether if the court were to find that to be reasonable.
All right, thank you. Mr. Smith,